This is a fantastic location, of course, and a fantastic group of people. So thank you for inviting us at Title Alliance to be with you today. One of the things we try to do every time we meet is to just give you some thoughts, some ideas that might help you with your operations. And yesterday you heard from Wayne about staffing and how important that is, and about agent development and development in general and how important that is. And most of you are well aware of TRID, the changes that are coming about the 3rd of October. And I can guarantee you that at least at Title Alliance, all of our title operations have been training for over a year, getting ready for that. That doesn't mean it's going to come easily, because it never does. There's always going to be issues and all of that, but I think that you find that whenever you're in an operation, a title operation, for example, with a real estate company, that the training is so very, very critical, and I'm glad that you talked about that yesterday. In addition to TRID and all the changes that are coming about there, the thing I want to talk to you about today is the CFPB and some of the changes that have occurred as a result of that. They recently have sort of shaken the fabric of the real estate industry with several cases, and the most important case probably for you is the Lighthouse case, because the Lighthouse Title Company case is one where a title company had several marketing services agreements, or MSAs, with realtors. And CFPB came along and basically said that they couldn't do that. Now, there's an old adage in law that says bad facts make bad law. And that's very true. The problem is we don't know what the facts are, per se, in this CFPB Lighthouse case. They never really tell you exactly what all the issues are. So the takeaway, the thing that I want you guys to pay attention to, is this. If you have a marketing services agreement with a title company or a mortgage company, you want to look at it. You want to talk to somebody about it, a RESPA attorney, and talk to them about it and make sure that you're doing everything right. The problem not only transcends if you and your real estate operation have that arrangement, but be very cautious. Make sure that your agents, if they do, that they in turn have talked to a RESPA attorney. That's pretty important. Usually the title company or the mortgage company that you work with will provide you with a copy of their opinion letter from their law firm. But you really want to make sure that you're doing that, because you, as the broker, if one of your agents is doing something that CFPB at least says isn't kosher, you've got to be wary. Outside, we have a list of 4 attorneys that we use, their contact information. If you want to just stop by, we're right outside the door here. And talk to us if you wish about anything like that. We have found that what has happened with CFPB taking over RESPA regulation from HUD, there has been an awful lot of murkiness. There's an awful lot of things that people just don't understand exactly what CFPB is trying to get to, and there are a number of cases that you want to look at. And even if you have your own direct operation, it probably wouldn't hurt to talk to a RESPA attorney. Make sure everything is working the way you want it to work. So that's the takeaway. Thank you very much for inviting us. This has been a really, really wonderful retreat, and I think that we want to thank all the people from RE/MAX International for inviting us here and for this great event. Thank you very much.